I've undertaken with Senator Leahy with regard to reforming a 1986 law called the Electronic Communications Privacy Act, a law that was passed when I was in the 9th grade, a law that was passed at a time when no one really knew what email was outside of a few circles inside government, the military, and a handful of elite universities, and that purports to give the government the power to read your emails without a warrant under certain circumstances, merely with the passage of time. Senator Sessions and I take different positions with regard to legislation supported by many, including Senator Sessions, regarding electronic communications transaction records. So Senator Sessions and I have a fundamentally different view.
We are going to leave the last few minutes of this Attorney General confirmation meeting from yesterday and go live now to today's Senate Judiciary Committee meeting. On the same issue, Chairman Chuck Grassley announced a vote on Senator Sessions' nomination yesterday, and that should be the first order of business. Live coverage here on C-SPAN 2.
You'll be coming to me for the invitation.
That's exactly what I was.
Senator Whitehouse, our rules require that we have 8 people here. But my staff says if you would ask consent to speak with less than a quorum, we could get started. Otherwise, I can't start.
All right, well, give me 1 second on that. Why don't we wait just for, at a minimum, for the ranking member, and then we'll proceed.
Okay. Well, that's right. I normally don't start until she comes in. I shouldn't even answer your question.
Now's the time to talk about who deserves his cats. Starting the same thing. Americans is that.
We have 7 now. Very well yesterday.
They can still report it out without I welcome every.
Is it on?
I welcome everybody back this morning. First, under conversation that several of us on this committee had, I think we have an agreement that Senator Whitehouse will speak for 20 minutes Senator Franken would speak for 22 minutes. After that, we would proceed to a vote. I understand from staff that Senator Crapo said that he doesn't need time this morning, and Senator Sass isn't here, but when Whitehouse gets done, I would call on Senator Sass for 45 seconds. He said he'd like to have.
30.
And, well, 30. So then I would plan after Senator Whitehouse and Senator Franken finish, then we would have a vote on a roll call vote. So Senator Whitehouse, would you start?
Thank you, Chairman. The Attorney General of the United States holds a vital and somewhat unique position in the federal government, tasked with significant responsibilities that must be executed independently, sometimes even in defiance of the White House's wishes and interests. The Attorney General is tasked with enforcing our laws fairly, justly, and even-handedly, as well as with protecting the civil and constitutional rights of all Americans. The Attorney General does not work for the President so much as for the people, and does not serve the administration so much as the law. I have served in the Department of Justice, and I have felt its esprit de corps and its pride as exemplified when Attorney General Ashcroft resisted White House pressure on warrantless wiretaps. The Department of Justice is well aware of the importance of its independence, and a successful Attorney General must be stalwart in protecting the department from political meddling by the administration or Congress. We need only look back to Attorney General Gonzalez's resignation to recall what can happen when an Attorney General yields to political pressure. The Attorney General also makes policy decisions about where and how to direct the department's $27 billion budget, and when and how to advise Congress to recommend new laws and modify existing policies. Policy choices an Attorney General makes can have a profound effect on individuals, communities, and the fabric of our nation, and they allow the Attorney General wide discretion. This is not just a matter of saying that he will follow the law. Americans should be able to trust that their Attorney General will not only enforce the laws with integrity and impartiality, but stand up for Americans of all stripes and fight on behalf of their rights. That's the prism through which I evaluate Senator Sessions' nomination. I've known the Senator for a decade, and I've enjoyed working with him on legislation, but the standard by which I evaluate an Attorney General nominee is whether Rhode Islanders can trust that his commitment to doing justice and ensuring equal protection of all Americans will be real and lasting, and not just a matter of nomination etiquette. I have reviewed Senator Sessions' career as an attorney and as a senator, as well as his testimony before the Judiciary Committee. I've reflected on my duties and experience as Attorney General and U.S. Attorney in Rhode Island. I've also listened closely to very strong and serious concerns from Rhode Islanders who have made it plain that they fear what Senator Sessions would do as head of the Justice Department. For every constituent of mine who has expressed support of his nomination, 15 have expressed opposition. Senator Sessions' record is clear. He fought against fixing our immigration system as the leading opponent of bipartisan legislation, which, had it passed, would have spared us the current debate over an ineffectual $16 billion wall. Senator Sessions fought against our bipartisan criminal justice and sentencing reform. Senator Sessions opposed reauthorizing the Violence Against Women Act, a bill which is so important to the Rhode Island Attorney General's office and the anti-domestic violence groups in our state. I suspect that Senator Sessions' opposition related to the bill's inclusion of protections for gay and lesbian couples, and his record on support of gay and lesbian Americans is alarming to many Rhode Islanders. Public statements and confirmation testimony by Senator Sessions suggest that he brings a religious preference to the department, that secular attorneys would be to him a suspect class compared to Christian attorneys. From the state of Roger Williams, founded on freedom of conscience, this is an alarming consideration. He has on numerous occasions used racially charged or downright offensive rhetoric to belittle broad groups of Americans, including, for instance, Rhode Island's wonderful Dominican community, saying that Dominicans come to this country basically to sponge and be useless. Well, tell that to Big Papi, David Ortiz, and the Red Sox fans of New England. He walked those statements back a bit in the nominations process, but again, one must wonder if this represents a true conversion rather than a nod to nomination etiquette, akin to Justice Roberts' howler about being a neutral judge who would just call balls and strikes. We have been burned by nomination etiquette before. Senator Sessions has a long history of demonstrated open hostility for bedrock civil rights laws and failed repeatedly to vigorously distance himself from extremist hate groups that hold him up as a champion of their perverse ideologies. Senator Sessions has called Breitbart News a bright spot. Breitbart has published countless baseless and inflammatory articles with titles like, "Birth Control Makes Women Unattractive and Crazy," "There's no bias against women in tech, they just suck at interviews," and Gabby Gifford's The Gun Control Movement's Human Shield. Senator Sessions has promised that as Attorney General he would work diligently to ensure that all Americans receive equal protection under our laws, but his record creates justifiable alarm among many Rhode Islanders that his promise is more a product of nomination etiquette than a nomination epiphany. In fairness, I should disclose that Senator Sessions' nomination carries additional baggage with me as the nominee of this president and this White House. On the campaign trail, the American people witnessed Donald Trump glorify sexual misconduct, mock a disabled reporter, and make disparaging remarks about immigrants and minorities, all with no pushback from Senator Sessions. We all witnessed chants of "lock her up," which Senator Sessions did not push back against and even excused in his hearing as, I quote, "humorously done." In mass rallies that also featured beatings and the press caged and vilified, this didn't seem very humorous to many Americans. Americans know that the good guys in the movie are not the ones in the mob. The good guy is the lawman who stands on the jailhouse porch and sends the mob home. That chant was un-American, and across the country it made honest prosecutors' stomachs turn. Not surprisingly, many Americans are fearful of what the Trump administration will mean for them, for their families, and for their country. Senator Sessions had so many opportunities to push back, and he availed himself prior to his nomination of none. The problems did not end with the campaign. President Trump and his family have brought more conflicts of interest to the White House than all other modern presidents and families combined. The proposed Trump domestic cabinet is an unprecedented swamp of conflicts of interest, failures of disclosure and divestment, and dark money secrets. The Trump White House traffics in alternate facts, operates vindictively, and is a haven for special interest influence, and they're just getting started. None of this is good. All of this suggests that there will be more or less constant occasion for investigation and even prosecution of this administration. In recent history, only Attorneys General Gonzalez, Meese, and Mitchell have been as politically close to their president as Senator Sessions would be. And the Gonzalez, Meese, and Mitchell tenures did not end well. I fear that unless publicly boxed in, Attorney General Sessions' default position would be to protect the administration. The department's public corruption work is ordinarily done within the secrecy of investigative privilege, particularly in the early stages where the fateful go, no-go decisions are made. So the pressure of publicity will ordinarily not be available. Let me add a word about climate change, which is a matter of grave concern to me and to Rhode Island, our ocean state. Climate change presents readily discernible truths on one side and a massive polluting industry that wants to deny them on the other side. Senator Sessions has persistently refused to discern those readily discernible truths and unfailingly lined up with that massive polluting industry. As a signal about how, as Attorney General, he would handle conflicts between truth and power, this is an ominous one. Recent events put these concerns into particularly sharp focus. The refugee order that the President has issued highlights the problems we face over Senator Sessions' nomination. On a bipartisan basis, experts have concluded that this will harm our national security. As has been reported in the media, a group of more than 100 former national security heavyweights from both political parties protested President Donald Trump's executive order on refugees in a letter last Monday. This order not only jeopardizes tens of thousands of lives, they wrote, it has caused a crisis right here in America and will do long-term damage to our national security. Simply put, they concluded this order will harm our national security. In addition to being a substantive backfire, the order was a procedural botch. As reporters have disclosed, Trump and his aides kept GOP congressional leaders almost completely in the dark about the most consequential act of his young presidency, a temporary ban on refugees and on anyone from 7 majority Muslim nations. Defense Secretary James Mattis and Homeland Security Secretary John Kelly fumed privately to associates over the weekend because they had been caught unaware. It became evident that the rollout of the executive order bordered between clumsy and dysfunctional. Even on Morning Joe, host Joe Scarborough said the weekend was a disgrace. On Capitol Hill, many Republicans close to leadership were frustrated that they received little to no guidance or advance notice about Trump's immigration and refugee directive. The opening days of this administration have been a gong show, but a gong show with a nuclear button. This dangerous state of affairs puts all of President Trump's nominees in a new light. As conservative columnist David Brooks has written, many Republican members of Congress have made a Faustian bargain with Donald Trump. They don't particularly admire him as a man, they don't trust him as an administrator, they don't agree with him on major issues, but they respect the grip he has on their voters. But if the last 10 days have made anything clear, it's this: the Republican Fausts are in an untenable position. The deal they've struck with the devil comes at too high a price. It really will cost them their soul. Even if Trump's ideology were not noxious, his incompetence is a threat to all around him. To say that it is amateur hour at the White House is to slander amateurs. The recent executive orders were drafted and signed without any normal agency review or even semi-coherent legal advice, filled with elemental errors that any nursery school student would have caught. I'm continuing with David Brooks's words here. It seems that the Trump administration is less a government than a small clique of bloggers and tweeters who are incommunicado with the people who actually help them get things done. Things will get really hairy when the world's problems are incoming. Third, it's become increasingly clear that the aroma of bigotry infuses the whole operation, and anybody who aligns too closely will end up sharing in the stench. Fourth, it is hard to think of any administration in recent memory on any level whose identity is so tainted by cruelty. The Trump administration is often harsh and never kind. It is quick to inflict suffering on the 8-year-old Syrian girl who's been bombed and strafed and lost her dad. Its deportation vows mean that in the years ahead, TV screens will be filled with weeping families being pulled apart. None of these traits will improve with time. As former Bush administration official Elliot Cohen wrote in The Atlantic, quote, "Precisely because the problem is one of temperament and character, it will not get better. It will get worse. As power intoxicates Trump and those around him, it will probably end in calamity." David Brooks concludes, Trump's first 10 days in office have made clear that this is not a normal administration. It is a problem that demands a response. It is a callous, bumbling group that demands either personal loyalty or the axe. With most administrations, you can agree sometimes and disagree other times, but this one is a danger to the party and the nation in its existential nature, and so sooner or later, all will have to choose which side they are on and live forever after with the choice. I ask unanimous consent that the full article be added at the conclusion of my remarks in the record.
Without objection, so ordered.
So it is increasingly getting to be stand-up time here in Congress. Nominees have to meet a higher standard when a White House traffics in alternative facts, is caught up in conspiracy theories, uses threats and bullying as its means of exercising its will, and is riddled with conflicts of interest. As David Brooks has said, this is not a normal administration. He did not mean this as a compliment. For all of these reasons, I think that we need a more independent Attorney General of the United States than Senator Sessions is likely to be, and I yield back any remaining time.
Senator Franken.
Thank you, Chairman Grassley, for the opportunity to speak, and I'd like to maybe borrow a minute or two of his time if I run over the 22 minutes. I join my Democratic colleagues in expressing my strong opposition to Senator Sessions' nomination. In my view, it's important that every member of this committee fully understands Senator Sessions' views on matters that he stands to influence as Attorney General. So, once he was nominated, I spent a good deal of time reviewing the information he submitted, his questionnaire, his supporting documents and materials, and the records of the record of his previous confirmation hearing before the committee back in 1986. I know Senator Sessions. We served together since I joined this body and the committee back in 2009. And while I enjoy a good relationship with him and I respect him as a colleague, Senator Sessions and I have very different views about most of the issues that come before this committee, particularly on matters of equal justice. So when I started reviewing his materials, I paid special attention to how he described his work on civil rights. And I noticed some discrepancies in the way he had described his involvement in civil rights cases filed during his time as a U.S. attorney. I asked Senator Sessions about these discrepancies during his hearing. I asked him about his claim that he had filed 20 or 30 desegregation cases, a claim he made in a 2009 interview with the National Review. In response, Senator Sessions said, quote, "The records do not show that there were 20 or 30 actually filed cases." He said of the claim, quote, "The record does not justify it." I then moved on to question him about 4 cases that he listed on his questionnaire, which asked him to list the, quote, 10 most significant litigated matters he personally handled. Among those 10 cases that he listed on his questionnaire were 3 voting rights cases and a desegregation case. Now, that surprised me. And that's because I know Senator Sessions and I know his record on voting rights. He's no champion of voting rights. He called the Voting Rights Act intrusive and complained about states with a history of discrimination being subject to preclearance. But here he seemed to be trumpeting his personal involvement in 3 voting rights cases and 1 school desegregation case. And I guess it just seemed to me that given his previous experience before this committee, and given the concern the civil rights advocates had expressed about his nomination, that perhaps Senator Sessions or the transition team was attempting to revise some of that history and to recast him as a civil rights champion. And as it turns out, that's exactly what was going on. 3 attorneys who worked on 3 of those 4 cases wrote an op-ed stating that Senator Sessions had no substantive involvement in the cases that he listed as being among the top 10 that he had personally handled during his entire career. And 2 of those attorneys also submitted testimony to that effect. One of them, Jerry Hebert, spent 21 years in the Justice Department's Civil Rights Division, during time which he litigated cases in Alabama and met Senator Sessions. Mr. Hebert also provided testimony to this committee in 1986, and much of it served as a basis for Republicans on that committee choosing to reject Senator Sessions' nomination to the federal bench. Now, after I questioned Senator Sessions about his claim of personally handling these 4 civil rights cases, Senator Cruz decided to weigh in on my line of questioning. He said that I had intended to undermine the nominee's character and integrity, and that my questioning was, quote, not backed by the facts. Senator Cruz then proceeded to mischaracterize and attack Mr. Hebert, whom he described as, quote, an individual who testified falsely before this committee. Let's talk about that. Back in 1986, Mr. Hebert and his supervisor at DOJ were called to the Hill without advance warning to be deposed. Mr. Hebert's supervisor incorrectly stated that when he was a U.S. attorney, Senator Sessions pressured the FBI to stop a voting rights investigation. Now, that was not the case. It wasn't Senator Sessions who did that. Mr. Hebert's supervisor got it wrong. He misremembered. When committee staff next deposed Mr. Hebert, he was asked whether he observed Senator Sessions interfere with DOJ cases, and Mr. Hebert replied, quote, I only know what happened with our Conecuh County case, but my supervisor is in a better position to talk about that than I am. Mr. Hebert continued, he and I both have a very fuzzy recollection about Conecuh County. It was my supervisor's case primarily. Then Senator Biden asked Mr. Hebert about this testimony the next day, and Mr. Hebert repeated the error. But after they testified, which again happened on very short notice, Mr. Hebert and his supervisor returned to DOJ and pulled the records from the case, from those cases. They themselves discovered their error, and they both immediately filed sworn declarations making clear that they were mistaken and that Senator Sessions did not interfere. It was Senator Sessions' predecessor who had interfered. Mr. Hebert and his supervisor did not recant their testimony. They simply corrected their testimony in writing in advance of the committee's vote on Senator Sessions. In Mr. Hebert's case, that meant he submitted a declaration in which he corrected 3 lines of testimony in what was a 24-page deposition, 3 lines. The rest of the testimony in Mr. Hebert's 24-page deposition was unaffected. But just to be safe, just to make sure that the committee didn't misunderstand the purpose of his declaration, Mr. Hebert made it crystal clear. He wrote, quote, "This revelation concerning the non-involvement of Mr. Jefferson Sessions in interfering in any voting rights investigations in the Southern District of Alabama does not affect in any way my other testimony rendered before the Senate Judiciary Committee on March 13, 1986. Mr. Hebert's supervisor, who was the one responsible for originally getting the facts wrong, also testified in person to correct the record." That's what happened. Those are the facts. But when describing this history, Senator Cruz misrepresented what happened. So I'd like to take this opportunity to set the record straight.
I object to the senator disparaging a fellow member of the committee here in his absence. I would think he'd...
Well, he should be here, first of all. Secondly, he disparaged me,
do it to his
Senator.
face.
Let him make his case, and then we'll go back to you.
Sure.
I object to the senator. We're here to talk about the president's nominee, not a colleague, and I object to disparaging...
Don't take this from my time.
...disparaging a colleague on this committee, and particularly in the colleague's absence. It's just not, it's untoward and it's inappropriate, and I object.
Okay.
Can I speak to that?
You can speak to it, but I think that we'd be better off if we just let it go at this point.
You mean let me continue my speech?
Yeah, would you do that, please?
I will, thank you. But just to be safe, just to make sure that, okay, I did that paragraph. This is what happened. Those are the facts. But when describing this history, Senator Cruz misrepresented what happened. So I'd like to take this opportunity to set the record straight.
I object again. The senator apparently can't get the message from the chairman that this is over the top and inappropriate.
I think the senator from Texas doesn't get the message from the chairman.
You put the chairman in an awful bad position at this point because I'm not sure that I know
where I'm going.
I don't disagree with anything Senator Cornyn said, but I'm not sure I want to rule anybody out of order, but could you please leave personalities out of it?
Can I explain what I'm doing here? Because Senator Cruz did the very thing that Senator Cornyn is accusing me of doing. In my absence, he misrepresented me. He misrepresented Mr. Hebert. He personally went after me. He personally impugned my integrity. You didn't object then, did you?
Okay.
I'm not sure I was here, and I'm not sure
I
agree
wasn't
with the
here
characterization.
either.
But
Let me continue,
It would be
sir.
a decent and honorable thing to do it in the senator's presence and not by
Well,
his
get
back.
him here, but he'll have a tape of it. Okay. Allow me to read from the hearing transcript. This is Senator Cruz talking to Senator Sessions. And what I'm doing here is I'm clarifying Senator Sessions' record.
Proceed.
Senator Cruz, now earlier in this hearing, Senator Franken engaged you in a discussion that I think was intended to try to undermine your character and integrity. And in particular, Senator Franken suggested that you had somehow misrepresented your record. It is unfortunate to see members of this body impugn the integrity of a fellow senator with whom we have served for years. It is particularly unfortunate when that attack is not backed up by the facts. Now let's talk about who is trying to impugn the integrity of another senator.
This is from Senator Sessions.
I would suggest that Senator Cruz was trying to impugn mine. But if you take the time to really examine the evidence, you will see that he's not making his case at all. Instead, he deliberately elides the truth, and this is about Senator Sessions. Let's go back to the transcript. Senator Cruz. Senator Sessions based his attack primarily on an op-ed written by an attorney, Gerald Hebert. There is an irony in relying on Mr. Hebert, because as you well know, in 1986, during your confirmation hearing, Mr. Hebert testified then and attacked you then, making false charges against you. And indeed, I would note, in the 1986 hearing, 2 days later, Mr. Hebert was forced to recant his testimony, to say that he had given false testimony to this committee, and indeed to say, quote, I apologize for any inconvenience caused Mr. Sessions on this committee by my prior testimony. So an individual who has testified falsely once before this committee, his op-ed is now the basis for Senator Franken's attack on you. Let's unpack this. Mr. Hebert was not, quote, forced to recant his testimony. He voluntarily corrected an error that he discovered himself. The committee did not catch him in a lie. He did not try to pull one over on the United States Senate. That's not what happened. As I noted, Mr. Hebert originally testified that he had, quote, a fuzzy recollection about the incident in question. Upon refreshing his recollection, he immediately and voluntarily corrected the record. But if you didn't know better, after listening to Senator Cruz, you would think Mr. Hebert was caught lying and that the entirety of his testimony was discredited. Again, this is just not what happened. Mr. Hebert did what a good lawyer does when he discovers he made a mistake. He forthrightly admitted his error, and he expeditiously corrected the record. But back to the transcript, Senator Cruz. And indeed, the basis of Senator Franken's attack is he claims you were uninvolved in several civil rights cases that were listed on your questionnaire. In 1986, Mr. Hebert testified, this is a quote from him, I have needed Mr. Sessions' help in those cases, and he has provided that help every step of the way. Is that correct? That is what Mr. Hebert testified. Senator Sessions, yes, that is correct. Now, once again, Senator Cruz elides the truth. The 4 civil rights cases that I questioned Senator Sessions about during his hearing, the 4 he claimed that to have personally handled, this is Senator Sessions, the guy we're talking about confirming or not confirming. They were not what Mr. Hebert was talking about in that quote from 1986. Mr. Hebert worked on a number of cases in the Southern District of Alabama, and he was speaking about how he had interacted with Senator Sessions generally. Now, to be clear, Mr. Hebert had explained to this committee that 2 of the 4 civil rights cases that Senator Sessions claimed credit for personally handling are cases that Mr. Hebert litigated himself personally. They were filed before Senator Sessions was the U.S. Attorney, and Senator Sessions was not involved. Nonetheless, Senator Cruz attempted to conflate how Senator Sessions and Mr. Hebert interacted generally with Senator Sessions' quite limited involvement in these civil rights cases. But since Senator Cruz brought up the assistance that Senator Sessions provided to Mr. Hebert, let's talk about that. After Senator Cruz mentioned this 1986 exchange, I called Mr. Hebert about it. And he explained to me that, yes, Senator Sessions did provide assistance. When Mr. Hebert and his team needed to work weekends, Senator Sessions gave him a key to his office. Senator Sessions gave Mr. Hebert permission to assign work to his secretary once. Now, none of the occasions that Mr. Hebert referenced were related to the 4 cases that Senator Sessions listed in his questionnaire. But regardless, what Senator Sessions didn't do, to be clear, was personally handle any of the cases Mr. Hebert that he filed. So let's be clear about what happened here. Senator Cruz suggested that Mr. Hebert's correction rendered the remainder of his 1986 testimony unreliable. And he suggested that Mr. Hebert knew it was false at the time he provided it. As I've explained, that's simply not true. But I would submit that Senator Cruz already knew that, because after he suggested that Mr. Hebert is a liar and unreliable, the senator from Texas himself relied upon Mr. Hebert's testimony about getting assistance from Senator Sessions in an attempt to rehabilitate the nominee. Back to the transcript, Senator Cruz. Now, in the 4 cases Senator Franken referred to, you reported all 4 of them in your supplement to the Judiciary Committee. Is that right? Senator Sessions, that is correct. Senator Cruz. Mr. Franken did not mention that. Now, here Senator Cruz chastised me for not mentioning that Senator Sessions submitted a supplement to his questionnaire, as if the contents of that supplement would somehow vindicate Senator Sessions. They don't. So let's talk about the supplement. Senator Cruz is correct. Senator Sessions did submit a supplement. And in that supplement, the nominee clarified that his role was to, quote, provide support for DOJ attorneys. Let me say that again, provide support for. He said he, quote, provided assistance and guidance, unquote, and, quote, cooperated with DOJ lawyers. Not quite personally handled, if you ask me. And I suspect that's why he felt the need to file the supplement. But notice how Senator Cruz explained the supplement during the hearing. Senator Cruz, let me point out, here is how you describe your involvement in your written submission to this committee. And here Senator Cruz quotes from the supplement, quote, for the cases described in 2, 4, 8, and 9. Now, these are the 4 cases that Senator Sessions claimed to have personally handled. My role, like most U.S. attorneys in the nation and with non-criminal civil rights cases, was to provide support for the Department of Justice Civil Rights Division's attorneys. I reviewed, supported, and co-signed complaints, motions, and other pleadings and briefs that were filed during my tenure as U.S. Attorney. I provided assistance and guidance to the civil rights attorneys, had an open-door policy, that's the key, with them, and cooperated with them in these cases. Senator Cruz continues to quote the supplement. For cases described in 6, I supervised litigation and signed the pleadings. Now, that is consistent with the 1986 testimony that you provided help every step of the way. Isn't that correct? He asked Senator Sessions. Well, I think so, yes, Senator Sessions says. Now, this is very important. Cases 2, 4, 8, and 9 are the 4 civil rights cases at issue. The 4 cases that Senator Sessions claimed to have personally handled, but in fact did not. In the supplement, Senator Sessions walks back that claim and says he only provided assistance. Case 6, which Senator Cruz took pains to mention, and which Senator Sessions claimed credit for supervising, was not a civil rights case. It was a public corruption case. Senator Cruz cleverly attempted to conflate the cases in order to make it seem as if Senator Sessions had in fact supervised litigation in a civil rights case. Senator Cruz neglected to point out that all 4 of the civil rights cases at issue here had either concluded or were still active back when Senator Sessions appeared before this committee in 1986. 30 years ago, though, Senator Sessions did not list any of these cases at all. Senator Cruz did not mention that. I wonder what changed between 1986 and now that caused these 4 civil rights cases to take on new significance for the nominee. It's hard to say. Look, Senator Cruz is a brilliant attorney, but he doesn't have a case here. And the fact of the matter is that Senator Sessions misrepresented his record by claiming to have personally handled cases that he simply did not handle. And the supplement he filed doesn't explain that misrepresentation away. It lays it bare for all to see. Senator Sessions would not have tolerated that kind of misrepresentation from a nominee before this committee. And none of us should either. We have an important job to do here, and it requires that each and every one of us understands the nominee's record accurately. It's not our job to shade his record or to distort the testimony that witnesses share with us and with the public. So I felt it necessary to correct the way in which the senator from Texas misrepresented Mr. Hebert's testimony and further distorted Senator Sessions' record on civil rights and voting rights. Now, about voting rights. During his hearing, I asked Senator Sessions about an extraordinary claim made by the then president-elect. In late November, the president-elect tweeted, quote, "In addition to winning the Electoral College in a landslide, I won the popular vote if you deduct the millions of people who voted illegally." Let me repeat that. The millions of people who voted illegally. Now let's pause for a fact check. President Trump lost popular vote to the tune of 2.86 million votes. That's a fact. It's not an alternative fact, it's a fact. So I asked Senator Sessions at the time, do you agree with the president-elect that millions of fraudulent votes had been cast? And he responded, quote, "I don't know what the president-elect meant or was thinking when he made that comment or what facts he may have had to justify his statement." Note that Senator Sessions didn't say whether or not he agreed, which was my question. Then I asked him whether he had talked to the president-elect about the issue, and Senator Sessions said, quote, "I have not talked to him about that in any depth." Now, the Department of Justice, under the Attorney General's leadership and direction, is tasked with protecting the right to vote and with prosecuting fraud. So it seems unusual to me that the president-elect would make such a bold claim asserting that a fraud of truly epic proportions had occurred and that he wouldn't bother to discuss it with the guy he appointed to be the nation's top cop. But that didn't seem to bother Senator Sessions. I know you're looking at the time, but I was interrupted, and I would like to finish my remarks as everyone else here got to yesterday. There's only a few pages remaining.
Proceed.
Thank you, Mr. Chairman. And I don't suppose this should come as a surprise, because another thing that didn't seem to bother Senator Sessions was the speed to which states previously covered by the Voting Rights Act moved to restrict voting rights after the Supreme Court's disastrous Shelby County decision. He and I discussed this at the hearing. The reason I brought it up is that claims of bogus voter fraud are routinely used to justify voter suppression. Claims of apocryphal fraud are what states point to when they pass restrictive laws. So understanding Senator Sessions' views on voting rights and understanding how he responded to the president-elect's outrageous claims of fraud, it's important as we try to figure out whether he is capable of protecting people's right to vote as Attorney General, to get his opinions on how people's right to vote. Senator Sessions has long been a critic of the Voting Rights Act. He voted to reauthorize the Voting Rights Act back in 2006, but every senator did. But when the Senate debated that reauthorization bill, Senator Sessions said that there is, quote, little present-day evidence, unquote, of states restricting access to the ballot box. He said the Voting Rights Act, quote, eliminated that discrimination. He complained that the Act's pre-clearance requirement unfairly targeted certain states. And he later celebrated the Shelby County decision, which gutted the Voting Rights Act. Now, when I questioned him about that during his hearing, when I pointed out that after Shelby County, states moved quickly to enact restrictions. He didn't seem concerned. Now, we discussed North Carolina, which enacted restrictions that the Fourth Circuit eventually described and overturned. They described it as targeting African Americans with, quote, almost surgical precision, and which prevented African American people from voting in the 2014 election. But all Senator Sessions managed to say was, quote, every election needs to be managed closely, and we need to ensure that there is integrity in it, and I do believe we regularly have fraudulent activities occur during election cycles. Senator Sessions believes we regularly have fraudulent activities during our election cycles. That might explain why he didn't talk with the President-elect in any depth about his claim that millions of fraudulent votes were cast. Senator Sessions perhaps didn't find it alarming because he believes there's a kernel of truth in that claim, but there is not. That claim has been fact-checked to death. Nearly 138 million votes were cast in the 2016 election. State officials found virtually no credible reports of fraud and no sign whatsoever of widespread fraud. In 2014, a comprehensive study examined elections over 14 years, during which time more than 1 billion ballots were cast, and found just 31 incidents of in-person voter fraud. But last week, after obsessing about how many people attended his inauguration, President Trump again claimed that he lost the popular vote because millions of undocumented immigrants cast illegal votes. Only this time, the president got more specific. It wasn't just millions of illegal votes. This time, he said it was somewhere between 3 million and 5 million fraudulent votes. I wonder how he came up with 3 million illegal votes. I wonder if it could have anything to do with the fact they lost by 2.86 million votes. This is beyond outrageous. This is profoundly disturbing. The president went on to repeat this lie on Twitter and on television before calling for a, quote, major investigation into voter fraud, including those registered to vote in 2 states, those who are illegal and even those registered to vote who are dead. Depending on the results, we will strengthen up voting procedures, he said. Now, President Trump tweeted that before he knew that among those registered to vote in 2 states are his chief strategist, Steve Bannon, his press secretary, Sean Spicer, his nominee for Treasury Secretary, Steve Mnuchin, his daughter, Tiffany Trump, and his son-in-law, Jared Kushner. Nonetheless,
Speed it up, please.
okay. Nonetheless, President Trump later announced that he would sign an executive order related to voter fraud. This raises serious concerns. And before the members of this committee vote on Senator Sessions' nomination, we deserve to know whether the president intends for the Attorney General or the Justice Department to lead this investigation. When the President of the United States lies about the existence of massive widespread fraud, it's the job of the Attorney General to call him out on it. The Attorney General has an obligation to tell it like it is. Senator Sessions may have said it best himself. When Sally Yates was nominated to be Deputy Attorney General, Senator Sessions questioned her during her confirmation hearing. He said, and I quote, "You have to watch out because people will be asking you to do things, and you'll just need to say no. Do you think the Attorney General has a responsibility to say no to the President if he asks for something that's improper? A lot of people have defended the Lynch nomination, for example, by saying, well, he appoints somebody who's going to execute his views. What's wrong with that? But if the views the President wants to execute are unlawful, should the Attorney General or the Deputy Attorney General say no?" Last page. Ms. Yates responded, quote, "Senator, I believe that the Attorney General or the Deputy Attorney General has an obligation to follow the law and the Constitution and to give their independent legal advice to the President." And as everyone here should agree, that's exactly what Ms. Yates did Monday night, whether you agree with it or not. This nation owes her a debt of gratitude. But Chairman Grassley, Senator Sessions has not demonstrated that he is capable of fulfilling the same obligation. Before this committee votes to advance this nomination, it's important that we know whether Senator Sessions is able or willing to separate fact from fiction and speak truth to power. I am not confident that he is, and I will be voting against him, and I want to thank the chairman for his indulgence.
You went over 8 minutes, and Senator Cornyn didn't take 8 minutes to state his position. Senator Sass, you've got 45 seconds. Please don't take 1 second more. Would you mind using the microphone?
In the interest of getting to the vote, I'll submit my statement for the record. Thank you, Chairman.
Okay. The clerk will call the roll.
Mr. Hatch.
Aye.
Mr. Graham.
Aye.
Mr. Cornyn.
Aye.
Mr. Lee.
Aye.
Mr. Cruz.
Aye.
Mr. Sass. Mr. Flake. Mr. Crapo. Mr. Tillis. Mr. Kennedy. Mrs. Feinstein.
No.
Mr. Leahy.
No.
Mr. Durbin.
No.
Mr. Whitehouse.
No.
Ms. Klobuchar. No. Mr. Franken.
No.
Mr. Coons.
No.
Mr. Blumenthal.
No.
Ms. Harona.
No.
Mr. Chairman.
Aye.
Mr. Chairman, the votes are 11 yeas, 9 nays.
The nomination is approved by the committee and will be reported to the floor. Meeting over.
Heard that the nomination of a man who will not protect the vulnerable. That's why we have an attorney general to protect the vulnerable. You are shameful. This body is shameful.
Where are they?
You might want to walk through about that. Sad day for American justice. All right. Senator Cruz, we're very sorry.
You and I just learned how to
Ms. Franken.
we have a disagreement. That I can assure you. I've got a record of doing that on both sides. And I believe he's taking the law, I think it's pretty serious. What we need that is this committee's obligation.